Lovely to be here. And firstly, thank you to Danny for inviting me to come and present to the Simply People Network. It's an absolute pleasure. Danny and I met back in 2016. I was working out earlier, and we've been kept in touch on and off since then. And obviously, I'm very pleased to support Danny and his networks, and obviously extend what I can in terms of knowledge and insight to all of you. So I'm really pleased to be here. Just in terms of just a couple of things from me, I tend to get carried away with myself when I'm doing these things. I'm so into what I'm talking about, I lose track of the show hand function. So Danny, if you're keeping an eye on that, or if anybody else does have a raise your hand, please shout out, because I sometimes, when I'm clicking my slides and I'm in my health and safety zone, I forget to look back at the raise your hand. But at the end, hopefully I'll be good to time, and there'll be plenty of space to answer any questions in the chat as well. So feel free to do that. Okay, so Danny gave me a really kind of thorough introduction. Thank you for that. A little bit about me on the screen there. I am a criminal defence lawyer by qualification, but I spent my last 10 years of my career in safety and kind of found my route into safety. I kind of wear a lot of different hats, and people sort of like to say, don't they, I make a little joke at the start, or so you know, jack of all trades, and I'm hopefully a master of some in terms of the type of work that I do. I do work across lots of different industries, and that gives me lots of different insight into different challenges and problems that people are having with health, safety, welfare. What I think is, and what you'll see throughout this presentation, is I think there are some general common themes, and what today is all about is kind of what's going on into 2022 and some of the stuff that's kind of coming through. Hopefully it will have an occupational health focus, and some of it might be broader into sort of safety remit as well. So hopefully there'll be something to take away from everybody. So yeah, and I've left my details up there on the screen because I like hearing from new people and just getting to know everybody and widening my own network. So do feel free to find me on LinkedIn or Twitter and the like. So without further ado, what we're going to kind of cover today is a really sort of whistle-stop tour. I kind of tend to kind of want to get as much in as possible to give you as much kind of takeaways as I can. And so if anybody does have questions which we either don't get to today, or you want to ask me offline again after today, then feel free. If there's anything in particular that you want more information about, then again, feel free to come and ask, and I'm more than happy to help share info as well. So what we tend to do is take a bit of a counter through what's on the screen today. So some of the areas I've identified which I think are particularly relevant are kind of COVID. We've been living with COVID for like what seems like forever. The last 2 years, been up and down, we've been in, we've been out, we've been locked in, locked out. But from the 1st of April, obviously that has been the most recent changes last week. So I'm going to touch on where we're at with COVID and what that kind of means going forwards. Occupational health generally, some of the things that we're seeing, focusing on kind of mental health, well-being, ISO 45003, kind of what that now means for businesses and the shift that we're seeing towards putting a bit of a more spotlight on occupational health, which is good to see. And then some other things on the screen there we'll take account through. Some of the latter, the supply chain issues, staffing and fire and building safety, doesn't obviously have an OH focus, but hopefully there'll be some stuff in there that might be relevant. I just wanted to kick off with kind of something I read the other day actually from Professor, I think it's Dame Carol Black, who actually is one of the main, she's a medical practitioner, but she's been historically one of the main government advisors advising about sort of well-being in the workplace and how we can all sort of work better and sort of the wellness element to work in terms. And she sort of said she wants to see a real strategic focus being put onto occupational health. And I definitely agree with that, because obviously in my world, health and safety lawyer, safety gets loads of press and has done, and the big shift has moved in towards safety, and the performance in terms of safety has got better. But I think occupational health perhaps doesn't, and well-being hasn't had as much focus as it should have done. And from a regulatory perspective and an enforcement perspective, it hasn't perhaps as well had the same appetite shown to it. 2016, we saw the definitive sentencing guidelines for health and safety offences, and that does include occupational health. And I think there needs to be a bit more of a strategic shift in terms of businesses' approach to sort of well-being. And so some of this that we're going to talk about this evening perhaps shows where we're kind of headed with that, and that it might now become more strategic, more of a boardroom issue, looking at occupational health and whole employee health, you know, as a major issue for employers. So without further ado, let's get straight in, and we're going to start off with our whistle-stop tour on COVID. So 1st of April, last week, Friday, it saw basically following the government's February announcement about the Living with COVID plan. 1st of April on Friday saw the lifting of really the last of the remaining legal specific restrictions that we had in place. So isolation, the legal requirement to isolate had already gone in February, as had other things. But on Friday of last week, there was kind of some major changes, which are now that employers do not no longer specifically have to have the controlling of transmission of COVID within the workplace as part of their workplace health and safety risk assessment. Now, whilst that is no longer a legal requirement to do so, I think many responsible employers will take the moral approach of still ensuring that their approach to what controls they take as a result of kind of trying to minimize COVID still are, they will ensure that they do take what's reasonable for their own work environments. Now that might depend on whether it's things like hospital and care settings. They might still have stricter controls than in others, but I think those employers now will kind of take heed of kind of what the current data and statistics are showing us, kind of where we're at in terms of COVID. Generally, the cases are currently rising because of obviously the lack now of controls in place, and so employers will still have a duty to things like increased ventilation or cleanliness within the workplace. Those are certainly embodied within other health and safety legislation, like the workplace health and safety welfare regulations. So I think employers will still sort of take heed, although there's no specific legal requirement now about COVID risk assessments for the workplace. One thing I wanted to mention is about RIDOR. So the Health and Safety Executive have now altered their guidance on this, which has mainly focused on where before, if it was reasonably likely that it actually was because of and yes, somebody's put there on the screen, it is England. I'm talking about changes predominantly in England. There will be shifts in Scotland and Wales, but they haven't come along quite yet as far as what England has. So this is within England focus. So yeah, if you do operate in other jurisdictions, then it's still worth checking in those jurisdictions what the current arrangements are, because they are slightly different to what are happening in England at the moment. So just coming back to RIDOR, the health and safety at work guidance was updated in that it used to be that if it was reasonably likely it could be shown that it had been caused by occupational exposure, then I think there was an obligation there still to report. Now it's very much focused the scope even more narrower to settings which are either working with it directly, such as hospital and care settings, and environments that are perhaps lab based and people might get exposure through an occupational transmission that way. The guidance has specifically said that any general transmission of COVID between employees now is not considered to be RIDOR reportable. So I think you can kind of perhaps take a little bit of relaxation in that now, that employees might get it, but it's not seen to be something that they're expecting employers to now RIDOR report unless in very specific circumstances. Testing, we've had a change around testing in that they're no longer free for anybody in the general public, apart from specific, again, examples, which include things like if you are particularly high risk or you've been directed by your GP to get tests and the like. And what does that mean for employers? Well, employers might have actually had testing policies before where they'd have provided testings free of charge to their staff. So now there might be a shift in that they might not want to adopt a testing program moving forward. On the other hand, they might still want to, and they might give a contribution towards staff testing if that's something that they want to do for their environment. They might encourage staff to still go and get testing of their own accord, of which people will have to now pay for. But I think the main point for me on testing, and a couple of queries that we've had already, are around things like vulnerable persons in the workplace. So if you've got higher risk individuals or vulnerable people, then indeed testing might be something that still employers will look to provide or as part of its arrangements to help accommodate those people within the workplace environment. Generally, I think the whole shift now with us living towards living with it in terms of a sort of a more everyday risk within a workplace context, it's sort of shining a light now on the whole issue about presenteeism and staff wellness. You know, it's also there's some new guidance out which is making COVID more of a public health issue, and saying that things like respiratory conditions in general, coughs and colds, should people be in the workplace if they've got coughs and colds, even if they're not COVID? Are they fitting well enough to be there? Should they be there? Can there be any other adjustments taken so that they could work in an alternative setting until they're well enough? I'm not an employment lawyer, but I know that that then throws up things like issues around sick pay and how employers might approach that. So there's a whole host of things at the moment with COVID, and I don't think that this sort of moving into the living with it will necessarily be straightforward. There might be a few bumps in the road, but we are having to sort of, you know, still act responsibly, I think. And from an employment perspective, that you don't want, again, major outbreaks within your staff networks. You know, we're all back to face-to-face events and more people meeting, but actually, you know, sort of having some level of control, increased sanitation, or perhaps managing numbers and who's with who might still be useful to some extent, so that you don't have masses of the workforce all out with COVID at the same time. The last thing I just mentioned is display screen equipment. So I think whilst they were sort of saying during the pandemic that kind of more hybrid working and sort of the homework and office-based work was perhaps a temporary solution, more and more companies now are moving to accommodating agile work policies and the like. So the display screen equipment guidance has now been updated, and ensuring that people have actually got now, they've reviewed their display screen equipment policies and procedures and their risk assessments to make sure that they have got them in place to comply with those regulations, because it's no longer something that's being viewed as a temporary measure. They're expecting employers that know that they've got staff now that are very much home based to have had display screen assessments as they would if they were office based. So that's kind of what I wanted to highlight in relation to kind of our current landscape and world of work. Occupational health. So indeed, I think we're seeing quite a shift, as I started at the outset here. We're trying to sort of level up a little bit in terms of whole employee health and making sure people are well to work and that they're kept safe while they're there. And that very much includes mental health and well-being and stress. You know, it's mental health stress awareness month this month, I think, and certainly employers in terms of their duties towards ensuring that people are not exposed to stress unnecessarily at the workplace is now a higher up issue for employers than ever before. I know that on health and safety executive visits, when they go out to people's workplaces for perhaps specific reasons that are not connected with mental health, they are actually asking about what employers are doing in terms of mental health compliance when they're there. And so they are proactively making some inquiries about how businesses are seeking to manage that. And obviously we've got very good guidance with the health and safety executive, you know, the management standards approach with 6 clear elements that employers are meant to consider in regards to staff mental health, and lots of businesses are doing loads that's proactive in this space, whether that might be mental health first aiders. I'm sure you've all heard about. I actually, at one of my old employers, was a champion and part of a working group about implementing something called the Mindful Business Charter. There are various different schemes out there at the moment which are trying to make business run smoother with less unnecessary stress. And that kind of thing. So there's definitely a shift coming, and I think whereas it wasn't seen perhaps before as an employer issue, mental health and well-being now is very much viewed in that round. We've also got you know, trade unions, external agencies such as Minds. They've long campaigned about things more being done to sort of ensure against sort of mental health issues being triggered as a result of the workplace. And in June of last year, 2021, we had the world's first new ISO standard that was introduced to bring more practical guidance for managing psychological risks in the workplace by way of ISO 45003. So this was the first standard that we've seen that's actually approached this particular issue, and it was to reinforce really existing guidance that we had in this space, but it also provides lots of further information about how the working environment can be improved with things like better communication, lightening the load and the pressures that people face as a result of work, but indeed better leadership and a shift in organisational culture, so that this actually is as given as much of priority to businesses health and safety agenda as any other issue and any other risk. So from my perspective, why wouldn't a business want to tackle this in the same way as other issues? And I think from an enforcement perspective, we perhaps haven't seen it, because when a regulator is looking at this, there are so many subjective factors how everybody might respond to stress. But what they're looking at now is, in fact, well, what is causing issues within the workplace? How many people might you have off because of work-related stress? And inquiries are being made as to whether or not there is anything that's common themes amongst staff as to what's contributing to that. So they are certainly now kind of inquiring more about it, and we'll have to watch this space and see what, if anything, comes from this in the future. I'm not aware of the Health and Safety Executive, for example, having taken any regulator action yet against an employer for this, but we'll have to watch this space and see. Manual handling as a really big area of focus. There's been a real sea shift in terms of HSE priorities, and certainly manual handling, occupational health has been up there for a while. There is now new digitisation in terms of manual handling risk assessment. So there's basically been the MAC and the RAP tools that are available, and they've basically combined them now into a new digital tool that's really readily available and easy to use, and basically will ensure that you have complied in terms of what the specific manual handling regulations require, because there's really prescriptive guidance about what a manual handling risk assessment needs to have to be suitable and sufficient. There's 1.7 million workers that suffer from work-related ill health, and 28% of those are musculoskeletal, and a vast proportion of those are from manual handling in some way. Big industries that have issues with that are kind of IC and logistics, parcel, distribution, anybody that's kind of dealing with fast consumer goods going in and out, that kind of thing, have got sort of manual handling is up there. And when the Health and Safety Executive does spot checks, they will again ask to see their risk assessments and stuff. So we're seeing innovation being a way of now complying and making things easier. So this digitization that there is for now manual handling, the Health and Safety Executive, they start to expect or will ask and make inquiries of whether duty holders have adopted those certain means in terms of their risk assessment process, and if not, why not? And is what you've got otherwise sufficient? Which it can be, but you just need to kind of ensure that you're aware of what's out there, and are you adopting the right practices now, given this kind of movement into a more digital world, I suppose. Hand-arm vibration syndrome. There was a presentation the other week that I attended with one of the principal inspectors for noise and vibration from the Health and Safety Executive, and for a while any RIDDOR report for a occupational disease of hand-arm vibration or carpal tunnel syndrome, for those that are working with vibrating tools in the workplace, any RIDDOR report of that nature does get a mandatory follow-up by the Health and Safety Executive to check on what might have given rise to it. Some issues there that are relevant, that duty holders are looking at more and more, is to ensure they're getting really good quality in their OH providers for things like assessments for HAVs, because there could be quite out there, I think that there can be all sorts of different people sort of saying that they know kind of what there is out there in this space medically, and people can actually get sort of tier 4 assessments done, but actually by occupational nurses rather than sort of registered medical practitioners. And so it's just making sure that kind of those that are delivering or saying they're delivering services in relation to hand-arm vibration are in fact fully competent and qualified to do so. And obviously just how your RIDDOR reporting as well, what information is put on that RIDDOR can be important, because it can lead to follow-up or not. Wood dust, I just mentioned there, I said occupational health generally is getting a greater focus by the regulator and also by business, and one of their current priorities that they're kind of focusing on us on wood dust. So they're doing focused inspections that are targeting this particular industry at the moment. So that's one to mention. Let us move now, if I can, to sexual harassment, because the government actually did a report into this in regards to a workplace context and what needed to change. I think, we've seen a lot of movement in this particular space, things like the Me Too movement, and people just wanting to raise the bar generally in terms of sort of cultural norms and this not being acceptable, in a modern age more than ever. And the government published its first formal response into sexual harassment in a workplace context. I think it was some point last year, middle to end of last year, the response came out. And they are actually going to legislate in this particular area, which places a positive duty on employers to actually take steps to prevent sexual harassment in a workplace context. We are expecting there to be a new code of practice, which is going to sort of solidify what is expected for employers to do. But many employers, because they already treat sort of things like this with very serious in nature, and they want to get ahead of the curve and sort of are looking at perhaps how could they, as part of their general kind of the culture and that the general movement in terms of wanting to kind of get this right, what can they do? So people are now reviewing things like anti-harassment policies, making sure that they're well known and understood, that they're communicated, that they're robust, and better training and raising awareness of this type of an issue. It kind of sits with mental health awareness and that kind of thing, making sure people know what is expected in relation to this and what isn't acceptable. And I know people might say, oh, isn't that not obvious? Do people not know that? But I think employers are taking proactive steps to say where they draw their lines and where they set boundaries in this sort of space would be useful, and that can help sort of be formulated in sort of from a safety perspective and a health perspective, and also an employment perspective. Would any conduct that would not be acceptable in the workplace then be subject to employment disciplinary proceedings and the like? So that's another area where we're going to look and see more movement and change for employers. Occupational road risk. Now, often employers will think that the obligations perhaps in relation to occupational road risk sits primarily with drivers, or the liability perhaps will be picked up by motor insurance policies, and it's not something to concern themselves from a health and safety perspective. But indeed, it is indeed as much of a health and safety risk, an occupational health risk, as anything else. And the health and safety executive have been keen to stress that this is very much an employer issue. And in that regard, from November 2021, the relevant guidance for occupational or work-related road risk was actually updated. And it was updated primarily to take into account changes that we're now seeing with the gig economy and how supply chain and drivers are actually being engaged to work for businesses. They're more and more using their own vehicles for work, classed as the grey fleet. And in the guidance also, for the very first time for this particular area, they have referenced that corporate manslaughter and gross negligence manslaughter can be looked at in relation to any workplace incident if it was to happen that somebody dies as a result of somebody's negligence in this particular space. And that might be from things like fatigue, for example, fatigue management, and not having adequate policies and procedures, and scheduling perhaps playing a part in how that driver has had an incident that's either led to their potential own safety issue, incident, or death, or fatal of them or of another. And if when the police attend, police tend to have primacy for investigating road traffic incidents. They will attend at the scene of a RTA in normal circumstances, and part of that triage process is to ask the drivers, were you in fact driving for work? And they have to tick a box that would say yes they are, and that might then perhaps lead to further questions being asked. And indeed, there's been a couple of prosecutions that we've seen. One actually was in a rail context with the ORR prosecuting a company in relation to fatigue management, and it led to a double fatality. And I think that was a few years ago now, perhaps 2 or 3, but that was the first prosecution that we'd seen in the regulatory space relating to, say, fatigue management for occupational road risk. So again, we're seeing a shift there, that general well-being and wanting to make sure people are safe and looked after mentally, from sleep patterns and the like, it's becoming ever the more important. Things in relation to general occupational road risk might be irrelevant, so driver fitness, drug and alcohol policies, mobile phone policies, vehicle maintenance, lone working, whole other host of issues. Health and safety prosecutions. As I'm sure many of you know, they can result in uninsurable loss and fines. And so reviewing these policies now must be kind of up there in terms of priorities for businesses, because it's not just down to driver error and the police will take action against them purely. They will look now more at employers' responsibilities in this particular space. I appreciate I'm going through this very fast, so I will take questions at the end as well. So I just want to make sure I get time to go through everything. So supply chain, we're generally seeing at the moment that there is a major change in terms of labour workforce. Many industries are still struggling, aren't they, to get back from the pandemic in terms of supply shortages of workers. I know various industries, whether it's hospitality, construction. I was actually speaking to somebody that's sort of in the food business today, food manufacturing business. They're struggling as well to retain and have labour the way that it did. And people, as well, we're kind of seeing changes with sort of getting more apprentices through the doors and sort of young people back into work, which is a great thing. And that's something everybody wants to sort of see. But in that as well, it kind of gives me slight pause, because actually when you look at when incidents are more likely to happen, it can be when people are new to the job and they're not familiar and they don't know quite how things work, and perhaps they're not as experienced as other people. So that again presents an issue. And I suppose in that sense, we're seeing changes and shifts in terms of how people are being brought within organisations, businesses, and indeed how they ensure that people are safe to do their job from the outset, and that whether people have got any prior existing health concerns that need to be addressed or acted upon before being put to work. Because I think people are keen to want to get business done, aren't they? They want to get everything going again, but not at the expense of their staff safety and health and welfare. So we're seeing a whole host of different change in this area. There's also been a 42% decline of workers from the EU, since the whole pandemic, which have gone home back to EU countries and perhaps haven't returned to the UK. So lots of things going on in this particular space. A couple of things I particularly want to mention. Personal protective equipment, so PPE regs, been around for a while, and certain tasks and operations will require PPE to be provided as part of, it's been considered as part of the risk assessment process in terms of risk mitigation. And the PPE regs used to be for employee requirements, but from the 6th of April, so actually a couple of days time, there is an amendment now to these regulations that will bring in the requirement to supply PPE where you've identified it's to be provided to all workers, whether that's labour only, casual staff, agency workers. Everybody is the same requirement for PPE as employees. So that's quite interesting, and that's again another change that we've seen to address the changes in the gig economy, as I've mentioned, and to make sure that everybody is given the same safety precautions as everybody else in a workplace context. Now, how that might affect employers going forward would depend on how they approach PPE requirements already, because some might, as standard, already issue it to everybody. Others might rely on their agencies to provide or supply PPE appropriately. So it depends on quite what you're doing already as to how, if at all, this PPE change might affect your businesses. But I think some employers are certainly revisiting their PPE policies and the risk assessments to see what their requirements on PPE supply are, because from the 6th it will apply to all workers. Competency is something that I think is getting increasingly more and more a focus. And I say that because already sort of sufficient information, instruction and training is very much required within health and safety law. There is that within certain sets of regulations and legislation that specifically require sufficient information, instruction and training to be given. And I think that, as I said, the whole change with more apprenticeships being offered, new staff being brought into the workplace, or perhaps diversifying from different jobs into a different industry they've never worked before, and therefore making sure that people are competent and have got the necessary skills is going to be ever the more important going forward. This last point is perhaps a little bit of an aside from health and safety, but just about general changes of movement of workers that are coming in, because there is going to be a whole sea change a little bit in spring of this year, and there's going to be 3 new routes in for immigration, which is helping to try and bring in different people to the workplace back into the UK. Obviously changes post-Brexit as well, and how this might be managed. So there's 3 things that I just wanted to mention. Global mobility mobility visas. They're expected to give businesses more flexibility to be moving staff around internationally, establishing business in the UK, and then having sort of second teams set up as opposed to just individuals from UK sites, and that's under the parameters of global mobility visas, something called a scale-up visa, which is expected to provide fast-track entry route for qualified persons, allowing businesses to scale up and facilitate highly skilled migration into the UK. And also high potential individual visas is expected to allow for an unsponsored route from those qualifying in top global university settings to come into the UK for work. They won't have to now have a minimum skills or salary level or a job offer requirement to come into the UK. And again, in that regard, it could bring a closer focus in terms of competency for the future. Now, I'm not a employment lawyer, I'm a health and safety lawyer, but I just think it was interesting to note that all these different changes about how workers can come into the UK is interesting. And that means that then obviously things like, you know, language, perhaps difficulties and challenges, communication is going to be ever the more important for businesses to kind of get that right, I think, from the off. One thing I would mention, my firm in particular, that if anybody was interested in that particular aspect, there is a webinar on the 27th of April that's by our immigration team that's kind of cover these in more detail and how employers can perhaps navigate those issues. So I thought I'd mention that. Then let us move to fire and building safety. So I don't know all the roles of everybody on the call and how relevant this will be or won't be to people, but just to my sort of way of a general overview, because you could do a whole session that's just geared upon on fire and building safety. Again, you know, post Grenfell, we had the Dame Judith Hackett review into the whole regime, basically, for fire and building safety, and are looking at all levels of the chain, how we were going to move this forward. And we've had now the Fire Safety Act 2021, parts of that are now in force and enacted, which is set to sort of shift and change responsible persons' duties for fire safety risk assessments and what's within scope. And we've got the Building Safety Bill actually going through Parliament at the moment. It had its 5th, I think, report stage last Tuesday. It was actually the 29th, where the bill was considered again and further amendments to the bill. And effectively, this is going to sort of shake up the whole system for duty holders, from those that build and design and plan buildings to those that then manage and those that manage the buildings and those actually in occupation. So it will actually go right the way through. It's intended that it wants persons to be more responsible for its buildings and have this golden thread of information about its buildings. What risk do they pose? How were they built? How might those things affect the occupants moving forward? And about that whole focus on transparency, sharing credible and reliable information. There is going to be 2 new regulators introduced, and that's both on terms of building safety generally and construction products, so how buildings are built and making sure that those are safe. The different roles have been introduced under the bill or are going to be introduced. So the accountable person is a new role to be introduced. Building safety manager was actually a role that the bill was set to introduce, and now no longer. Since the last review, building safety managers are now not going to be a set role, and there's been quite interesting debate about that, because a lot of duty holders have already moved to introduce building safety managers, and now people are saying, well, why has that been removed? And I think from my 2 pence on that was that I think there was a need to want to show that they were not going to pass these costs on to residents and tenants to pay for the likes of an introduction of a building safety manager. And also it was seen that people might already have actually the resources available to them and the knowledge internally without appointing a building safety manager, so they could rely on sort of people that they already had to maybe upscale or to review the buildings rather than introduce a new role to do it. I think that was the reasons why that element had been removed. Some other things that they're going to be doing to building safety cases, which is effectively a whole comprehensive basically an analysis, risk assessment approach, proportionate approach about building safety, what ought to be considered from the whole remit of the build, and again engaging the residents properly so that they also know how fire safety risk assessments have been approached, what the fire safety strategy at buildings are and why, and that they're engaged and consulted as part of the process, which has been, you know, as a result of the Grenfell public inquiry and the Hackett review, was that that hadn't happened before. So again, this whole cultural shift that we're seeing is very much as well at the heart of what we're seeing in the fire and building safety space. There is an industry safety steering group that had actually published its third report into how companies were doing in this area. I think they published it was either earlier this year or again at the end of last, and that actually said that it felt there was more needing to be done, because I think quite a lot of duty holders might be saying, well, we're waiting until the law is finalised before we kind of change our tact. But what they're saying is they don't want the law here to be the thing that makes people move and change. They want people to drive forward proactive change from within, as sort of this change and shift that we're seeing generally, as I've mentioned, but you know, the cultural side of all of this, and it being the right thing to do, and to get ahead of that curve, and to do things already. And how might businesses do it? Well, there's the building a safer future charter, the code for construction product information, are two recognised schemes that all the key stakeholders in this space have recognised, and kind of most public procurement contracts now actually expect that the parties involved should be signed up to this building safer future charter, because that actually gives a level of assurance about the steps that those people are taking in relation to the changes brought about in this particular space. There is a new methodology now as well for approaching, say, external fire assessments for your external facades of your buildings. That is now PAS 9980 and was published in January 22, so only very recently. And that new methodology was about approaching and adopting a more proportionate approach to how you go about assessing, say, the risk posed from your external facades. The future, really, and beyond, and what else might be in store. So I think ESG, environmental, social and governance, is also something that is commonly talked about in terms of other businesses being expected to ensure that they help with things like, you know, the UK's commitment to climate change and wanting to do the right thing. You know, we've got a campaign at the moment, and some of you might have heard, like the Better Business Act, which is basically a lobbying campaign at the moment, which is about trying to change, actually under the Companies Act, how businesses account for things in their corporate accounts and what approach businesses take to their social responsibilities, you know, the ethical business argument, and seeing businesses seem to put people at the heart of what they do. There's a lot being done at the moment in this space, which really is only going to help sort of further shine the light on things like occupational health and all of the different things that we've talked about today. Net zero, decarbonisation, you know, that whole piece about wanting to achieve our 2050 UK goals towards climate change. A lot of businesses are doing stuff to become more sustainable and sort of morally do the right thing. Digitalisation, we've mentioned that in the context of manual handling, and we're seeing that in lots of different areas. I think there is far more to come in that space. There's actually a tool now the HSE has released very recently, which is a culture assessment tool, trying to get businesses to actually measure and look at their culture and how they are approaching some of these areas, and what they might be able to do differently going forward. Digitalisation is a good thing. You know, it's a sign of the times. We're moving far more tech, aren't we? More different innovative ways of perhaps working with our hybrid meetings via Teams and all of the like. I think from a safety perspective or an occupational health perspective, you know, things like HAVS monitoring that's done digitally, and perhaps occupational fleet management or road risk that's managed digitally. A great thing can come out of digital assessments. I think my key thing to stress for duty holders is that having that now is great, makes life easier, that's what it's there for, but it's only so good as what you perhaps do with it. You know, data and digital is good and it creates a great deal of output, but indeed reviewing that output, making sure you've assessed it properly, whether there's any trends, having that data at hand and reviewed properly is so important. So there's pros and cons in my sort of space, and as a lawyer I will often ask clients, what have you got? Is what's available digitally? Have you looked at it? It's no good having the data if in fact it's not been looked at. So that's kind of one of the important things. Gas safety regulations. there was a consultation that was recently opened and closed. It opened in January, closed in March, and that was basically the government looking to actually diversify gas resources, change some of the things to do with gas processes, making gas supply greener and easier. So there might be some updated changes to come to our gas safety regulations after this consultation has been considered. And the last thing I just wanted to mention was asbestos, because actually we might think that we do a lot already to manage asbestos and any asbestos related occupational health issues that arise in the workplace. Since 2018, there's been a big push in reduction of occupational cancer and ill health that had been brought about by asbestos related incidents. I think there's potentially been a little bit of a lack of awareness still in this space and across trades about asbestos. And, you know, I've had multiple incidents where things like getting surveys done, but they're not checking the output from the survey, or you know, not actually having proper occupational health regimes in place to monitor people's exposure and the like have been relevant factors to people not managing this properly. And so I think IOSH actually, in fact, campaigning at the moment about trying to further improve the landscape in terms of asbestos controls. That might be with the possibility of introducing a national digital register for asbestos in domestic buildings, and also improving the requirements for training to employees working with asbestos. I think there've been in particular sort of concerns about, again, that whole apprentice workforce coming through, you know, and their knowledge as well about asbestos and what to be aware of when working in those sorts of environments. So that is one I'm going to put up there as a one to watch, because I think there might be more to come in terms of how kind of the control arrangements in regards to asbestos management for our future. So that has actually brought me quite timely through to the end of my presentation, and I know we've got some questions perhaps or comments in the Q&A box. I don't know if we've got any hands up, but I'd be more than happy to take any questions.
Thanks, Emma. There's a couple of questions. I can't turn my video back on, so we'll stick with the questions in the text box. Tracy asks, in respect to the health and safety changes from the 6th of April, regarding PPE, was this not already in place where a level of risk has been identified? Is there not a legal duty of care for employers to provide PPE? Thanks.
Specifically in the regulations, it was only for employers, I think, and I'd have to double check how they were phrased, but it didn't actually include all workforce effectively as being sort of an employer responsibility before. But now from the 6th of April, it will. So however they were worded before, and yes, you would expect them, because obviously normal, just general health and safety duties, you've got Section 3 of the Health and Safety Work Act to positively ensure health, safety, welfare of non-employees so far as reasonably practicable. So you would have expected that, but often not. So if it was like labour only or casual labourers, they might expect them to bring their own, or agencies might actually supply it, and actually are agencies supplying the right thing? Is it in line with a company's own PPE requirements and arrangements? So I think they've just tried to, for belt and braces, make it explicitly part of the regulations from April, so there can be no doubt about it, and that sits with the employer for whose undertaking those employees are discharging. So it's worth a review just to check that you're happy that in fact everybody has got the correct and proper PPE post that date.
Perfect. Thank you, Emma. I hope that's answered your question, Tracy. Libby, Emma, are you aware of any instances where work-related stress was badly managed by an organisation and the worker was awarded compensation? She's aware of Young versus the Post Office 2002, but do you know of any others?
Would that be on a civil case or claim on in a civil context for personal injury? Is it Libby?
It was Libby.
Yeah, don't know. I'm not familiar with that case, but it may well be that, yeah, somebody's put in a sort of civil claim for personal injury or compensation, saying that if, you know, as a result of their work, they've perhaps then suffered work-related stress, been off and made a claim. So it's not an area that I specifically practice, but it certainly remains a risk, yeah, that people could bring as well civil claims for that compensation. And you know, all employers have a duty of care to their employees, and therefore, if, for example, employers have not sought to manage this issue properly, and there could be shown to be that causal link between somebody's work environment, the pressures they're under, and their mental health, and that being something the employer was on notice about and therefore could and should have done more about, then yeah, they could very easily have brought a claim and been awarded compensation for that. But I'm happy to have a little look around, and I can come back to you offline. If you drop me perhaps a line, I can have a look and see what other cases there might be of that nature. I think it's difficult as well for employers because everybody presents at work, don't they? And it's not a legal obligation to tell your employer necessarily how you're feeling. And I've had cases where employers have not been on notice at all, and actually somebody has been really suffering. So it's kind of dependent on as well, you knowing and asking, I suppose, the right questions and saying what you're told. And certainly you're on notice about something, then there's no excuses left for making a reasonable adjustment or supporting that person. But I think that's what this is all intended to do, is to kind of even it up a bit more, so employers are asking the right things and being mindful of the way that their work is done to prevent anything like that happening going forward.
Emma, if you want to share that with me, I can pass that around with the information afterwards, if that helps.
Yeah, no, by all means, I'll have a look and see what kind of things I can kind of find on that, and I'll share it back with Danny.
Thank you very much. Someone asked if you can just run through again what you said about the drivers, please. About
drivers, yeah. So obviously anybody that drives for work, if that's in a work vehicle, then that will be classed as occupational road risk. If they drive their own vehicle and it's more than just driving to and from work, so they actually drive with their own vehicle for business and on work activity, then that would be classed as grey fleet, we tend to call it. And that then means those vehicles are captured within the scope of an employer's obligation. So ensuring that those vehicles are actually fit for use. So are we satisfied they're MOT'd and serviced properly, even though there might be the individual's responsibility to do it? Does fall something that employers ought to be checking if they've got a lot of people out using their own vehicles. And then things like driver licensing checks or fitness for drivers to work, depending on the nature of what they're driving about for. Have you got a driving at work policy? Have you taken into account things like driver fitness, if you have to, alcohol or drugs policies, mobile phone policies, and fatigue management, scheduling? It's all those sorts of factors. And now they're very much viewed as an employer issue as well as an employee issue. And so the guidance that's out there, I can send people a link to the guidance if they want, but it's out there for occupational road risk management. And in there, I think it was November of last year, it was updated, and it included that corporate manslaughter and gross negligence manslaughter can arise if an employer could be found grossly negligent of not managing the risks that arise from work-related road risk. So I think that's an area to have a look at. If you do have a big fleet or you've got a lot of people using their vehicles for work, then I'd recommend certainly having a driving at work policy to take into account some of those things.
Perfect. Thank you, Emma. Renu asks, where do the police force stand if they don't have a stress risk assessment in place? They've noticed police forces, they've noticed increasing referrals of stress, which are more organisational issues.
Right.
Put you on the spot, sorry.
No, it's fine. Well, for stress, that will be the HSE or local authority, EHO, that would regulate that issue. The police would not regulate for stress in the workplace. The only thing that police get involved with for health and safety in the health and safety world is corporate manslaughter. So if they felt that an employer had, by its acts or its omissions, had in some way caused or contributed to a death, and that also the senior managers of that organisation had somehow caused or contributed to that failing, and it was so far short to be negligent, grossly negligent, then the police can investigate for corporate manslaughter. But I don't see that necessarily following through for things like mental health. But the health and safety executive and local authorities, they can certainly ask for stress risk assessments, or how do you approach mental health and wellbeing in the workplace. There's readily accessible guidance for that issue, and they'd expect employers to be aware of that and have something in place. So worth having a look if you haven't already.